Hi doctor, my name is Kanchana Viswalingam. My matching number is EX036226. Today I'm here to present my oral video presentation about its summary of the topics. First of all, I would like to thank Dr. Rosanna who taught me this subject, mgm4321 company law, which doctor made me clear each and every topics of the subject, which made me realize that company law is very important. Thank you, doctor, for this. First of all, I would like to start with the topic 1, which is classification of company, types of company. There are three types of company, which is company limited by share, unlimited company, and company limited by guarantee. Okay. Company limited by share. Okay, in company limited by share, the liability of member is limited to extent of the amount which not paid by them on their shares. This means that in case of winding up, the member will be liable only when they pay the remaining amount of their shares. Okay, in section 10 clause 3, a company limited by guarantee is the liability of its member is limited to such amount as the members undertake to contribute in the event of its being wound up. In section 10 clause 3, a company is unlimited company if there is no limit on the liability of its member. To differentiate an unlimited company, the name of unlimited company should end with Sendirian. Okay. Private company and public company. A private company is a company to have the following characteristics, which is it has not more than 50 shareholder. It is restrict the transfer of its shares. Public company is namely should end with Berhad, and a public company may have one or more of the characteristics of the imposed on a private company. Okay, for example, most public company is limited by share. Next, I'm going to explain about the company formation. Okay, company formation. Promoter. Promoter is a person who originates the idea, registration, and incorporation of a company. Function of a promoter. To collect the requisite the number of person, example, in 7 in case of public company and 2 in case of private company, who can sign the memorandum of association and articles of association of the company, and also agree act as the first director of company, and to decide about the following, which is the name of the company, the location of its register office, and more. Okay, pre-incorporation contract. Okay, a pre-incorporation contract is defined under section 65 clause 1 CA 2016. Okay, it is a contract or transaction that be made by or on behalf of a company at a time when the company is not being formed. In section 65 clause 1, provide that the person who signs the pre-incorporation contract will be personally liable on the contract or the transaction accordingly. Okay. Section 65 clause 2 permits that the company to ratify the contract or after its incorporation. If the company does ratify the contract, the company should be bound by the contract or transaction as if the company has been in existence at the date of the contract of transaction and had been party to the contract of transaction. Post incorporation contract. Okay, under section 190 clause 1, where a public company having a share capital has issued a prospectus inviting the public to subscribe for the shares that issued under the Capital Market and also Service Act 2007, in relation to its shares, the public company should be entitled to commence any business, to exercise any borrowing power. Okay, if no money is or may become the liable to be repaid to applicants or for any share or debentures offered for public subscription by reason of any failure to apply or obtain permission for listing for quotation on any stock exchange. Okay, the next topic, the second topic is company status. Company stated under separate legal entity under section 20 of CA 2016. A company incorporated under the Act is a body, corporate, and should have a legal personality separate that from its member, and it continue in existence until it removed from the register. In addition, Section 192 Clause 1 express that it provide a member shall not be liable for an obligation of a company by reason of being a member of the company. Okay, the principle of the company upon incorporation is a legal entity separate from its member. Okay, was affirmed by which is a case in case of Salomon versus Salomon Co Ltd. It is the immaterial whether the company has the minimum number of members under the Company Act 2016. The minimum number of member is only one or has a large number of members. Next topic is the company constitution. Okay, based on what I understand, company constitution is a company is no longer required to have the memorandum of associate and also article of association for registration purpose. Okay, the constitution is optional for company limited by share. Okay, however, company limited by guarantee is still required to have a constitution at the point of incorporation. A company may adopt a constitution after its registration by passing a special resolution. For a company limited by shares that choose to have a constitution, company and director and shareholder are bound by the rights, power, duties, and obligation stated under Company Act 2016. Okay, extend that such provision are modified by the Constitution, and such modification will permitted and do not contravene the Company Act 2016. Okay, object clause are usually very specific. Okay, but a general purpose object clause is may still be included to allow the company to engage in any business that the members of director think. Doctrine ultravirus. Okay, what is doctrine ultravirus? Doctrine ultravirus is a part of reintroducing ultravirus with CA 2016 abolished the doctrine of constructive notice in relation for the constitution of a company or a document when it has been registered by the registrar or is available for inspection at the register office of the company. Section 39 of CA 2016 it no longer apply to dealing as MOA and AOA are no longer compulsory document. Taekwondo rule. Taekwondo rule is an outsider who is the third party may assume all the internal matters of the company director power of authority and has performed the available checks to comply with the minimum duty imposed by the law. The doctrine of constructive notice of public documents other than instrument by charges will not apply to event which transpired after the coming into force of CA 2016. The one rule is inapplicable in instance which where it is representation of authority has been made solely by the person with no authority. Topic. The next topic is about appointment of director. Director is most of knows as director is the head of the organization and have some duties and power of management and also the administration. Okay, minimum number of director. Okay, in CA 2016, Section 196 Clause 1 provides that a private company should have a minimum one director who ordinarily resides in Malaysia by having a principal place or resident in Malaysia. For a public company, it should be have a minimum 2 resident director. Okay, the qualification. The qualification in directed in CA 2016 removed that Age limit, remove the age limit for director of public company. A director over 70 years old age is required to be a director, and no additional administration procedure is required. Disqualification of director: a person should not hold office as a director of a company, or whether directly or indirectly the concern takes part in the management of company. It is the person undischarged bankrupt, has been convicted an offence to the promotion, formation of management, has been convicted of an offence involve fraud, dishonesty. Okay, director remuneration. Okay, director remuneration for public company is the fees and benefit payable to directors for public company and public listed company, and its subsidiary include the compensation for loss and loss of office must be approved by the general meeting. For the private company, the fees and any benefit payable to a director are to be determined by the board of directors. Next, I'm going to explain about share capital. Next topic is share capital. Okay, share capital is it's about the consequences of the move to no par value. The Company Act 2016 introduced the no par value environment. In Section 74 of the Company Act 2016 provides that all shares issued before or upon the commencement of the Company Act 2016 in no par value, shares are issued at a price or to be determined by the directors. Under the Company Act 2016, a newly incorporated company is not required to state its authorized share capital or the nominal value of its share. Power to issue shares. Okay, the power to issue shares is accessible by the director, but the prior approval to the shareholder by the way of resolution of the company must be obtained before the directors can allot the shares. Section 75 of Company Act 2016 required that a prior approval of the shareholder obtained before the director can exercise the following power, which is the grant right to subscribe for share, convert any security into share of the company, or to allot share under the agreement of option of for offer. The approval may be given with or without condition and may be confined with specific exercise of the power, or may apply to exercise power generally. Okay, the general meeting reserve the power revoke or vary any approval of previously given in Section 76 Clause 4. Okay, let us see. The next topic is about meeting. Okay, meeting is in as what I read in Company 2016 provides that meeting may be convened by the following, which is the board of director by any member. Such member must hold at least 10% of share capital, issued share capital of the company, or lower specified in the constitution, or if the company has no share capital by at least 5% of number of members by the director when requested by member in section 311 by the court. When a request is made by members who fulfill the shareholding of membership requirement, the director must convene a meeting within 14 days from the date of the requisition. Okay, next topic is about members. Members is a person name who enter in the register of member. Becoming a member under Section 18 Clause 2, the Company Act 2016, member delegates certain power of the company directors to run the company in their behalf. The right to exercise and to vote attached to the share. Firstly, in the circumstances, not all ordinary shares and preference shares have voting rights. For instance, Section 90 Clause 2 together with the Section 90 Clause 3 of CA 2006 reveals that company may issue ordinary share which do not entitle holder to vote of the company general meeting. the right to receive notice of meetings of the members. Secondly, he is entitled to receive notice of meetings of the members, which is accordance with the section 101 clause 2, annual general meeting of public company. Okay, a public company is required to hold an AGM in every calendar year. The Company Act 2016 require that AGM must consider the following method, which is audited financial statement and the report of directors and auditors. Appointment and fixing of directors also under the Company Act 2016, and the AGM must be held within a 6 months of the company financial year and not more than 15 months after the last proceeding of AGM. Let us see the next topic. The next topic is about corporate rescue scheme. There are four corporate rescue scheme, which is first is moratorium scheme and arrangement. Okay, it gives the court power to order a compromise arrangement with creditors and also members in the form of an approved debt restructuring arrangement. The term arrangement is include reorganization of share capital of a company by the consolidation of shares, by the division shares of different classes. Okay, the arrangement of reconstruction promotion is commonly referred as a scheme of arrangement. Okay, is commonly by companies to restructure the debt of the creditors. Second is statutory scheme of arrangement. Okay, in restraining order in section 368. Okay, an applicant must be meet the statutory scheme of condition for a grant of a moratorium, known as a restraining order. Under Malaysia scheme of arrangement, even at the initial application stage, there is a new 3-month period for restraining order, which may be extended by the court if the company applies for the extension. However, the court cannot extend the restraining order for more than 9 months. A restraining order cannot be applied against any action of proceeding to be taken against the company by the registrar or the Security Commission, or by any action or proceeding against any person, including the guarantee of the company, but does not exclude the company that apply for restraining order. The third is proposed corporate voluntary arrangement. Okay, a corporate voluntary arrangement is a procedure which allow a company to put up its creditor for voluntary arrangement. Corporate voluntary arrangement is a management driven restructuring process with minimal cost involvement, which is quick and also low cost. The proposal must include nomination of nominee either as a trustee or supervisor under section 396 clause 2 of the Company Act 2016, and a statement that the company's information is up to date and the company is not under any striking off. Okay, the fourth is judicial management. Okay, judicial management is allow a distressed company or its creditor to apply in order to place the company under the management of a qualified insolvency practitioner, a judicial manager. Okay, the role of a judicial manager is to prepare and take a restructuring plan for creditors' approval. Okay, effect of judicial order. Okay, effect is an automatic morality order to stay legal proceeding for 180 days, and then within 60 days the restructuring plan will be tabled at the creditors in meeting. Okay, next is the last topic of the this subject, winding up. Okay, winding up. Okay, there are certain area of uncertainty in the winding up of provision of Act 2016. Under Section 443, a declaration of solvency is required before a company may commence a member voluntary winding up. The majority of the director must make a written declaration that they have made an inquiry into the company affair and at the board meeting have formed an opinion that the company is able to pay its debt to full within period not exceeding 12 months after the commencement of winding up. Okay, the Company Act 2016 provide that the time of commencement of a compulsory winding up has been changed from the presentation of the petition to wind up the company to time to order to wind up the company is made by the court. Consequent changes are made to ensure that the company and the creditors' interests are not adversely affected. The court has the power to restrain proceeding against the company at any time as after the presentation of the petition and before a winding order is made. Lastly, this subject company law helps me gain a lot of information about the company formation until the company wind up. Um, I gain a lot of information. This will help me in future for sure. Thank you, Dr. Rosanna, for teach me. Every topics in this is well explained, and uh, thanks thank you for everything, doctor. That's all from me. Thank you.
Let's meet the board of Approved Software Limited. It's a fictional company, and they're going to be helping us with some of the points we're going to cover today.
Hello, I'm Ashley Saunders. I'm Chairman and Managing Director of Approved Software. It's a new company, just under a year old, and I own 30% of the shares. Business is pretty good, I'm pleased to say.
I'm Jenna Hall, the Sales Director, and I own 20% of the shares. I joined the company 6 months ago as part of Ashley's plan to grow the company with a pretty ambitious business plan.
I'm James Blake, and I'm the Product Development Director here. I joined the business almost a year ago, and 2 months ago I was made a director. I also own 20% of the shares.
And finally, I'm Diana Thomas, the Financial Controller and Company Secretary. I'm not on the board, but I do hope to be made a director at the end of the year. I don't own any shares currently.
Some people are directors without ever having been properly appointed, and they might not even realise it. I'm thinking of a de facto director and a shadow director. It's a bad idea because they've got none of the rights and almost all of the responsibilities. And that means that they could be prosecuted like the other directors if something wrong is done, and they could even be personally liable for the debts if the company trades whilst insolvent, for example. It doesn't often happen, but the risk is there.
You've got me worried. My boyfriend is not on the board of his company, but he uses the title Director of Sales. Is he at risk of any of these things?
Does he go to board meetings and does he vote?
Yes.
Then he probably is a de facto director. It's not a problem if somebody goes to a board meeting and gives advice without voting. That's what Diana does. Now let's see how it's done properly. It all depends on the articles, but there are many possibilities. A lot of people, for example, don't know that it's possible for a company to be a director of another company. If you have the model articles, appointment is by an ordinary resolution of the shareholders or a decision of the directors. In both cases, the decision should be minuted. The new director must be at least 16, not disqualified, and unless there is special permission from the court, not an undischarged bankrupt. Needless to say, the person appointed has to agree. You can't make somebody a director against their will. Details of the new director must go into the company's register and on the form that must go to Companies House within 14 days. The form must be signed on behalf of the company by